Jack Smith must be disqualified. That is what former Attorney General Ed Meese says at the Supreme Court. Now, we've already gone through some Ed Meese filings before, and they're great. Why? Because they say that all of this should go away because Jack Smith has been illegally appointed. He was not appointed by the president, Joe Biden. He was not confirmed by the Senate. And the rules say before you have a special counsel, you got to go through the proper appointment mechanisms. And so Ed Meese, along with two other law professors who are very smart, intelligent individuals, they've sent this in to the Supreme Court, and this case is on appeal from Judge Chutkan's courtroom. And they're saying, look, Supreme Court, you have to grant a stay in the lower level case, or you got to dismiss this case. You got to resolve this because Jack Smith is illegitimate and the case can't be prosecuted by an illegitimate prosecutor. All of the prosecution power emanates from this individual to do their due diligence. They swear and all the things, and he's illegal. So it's got to go. And they're making this known to the Supreme Court. We'll see what the Supreme Court says about it. And we'll also hear from Brian Kemp, who talked about what he thinks about Trump's immunity, which of course is the issue in SCOTUS. So let's jump right into the filing. You see, this is a very important case. In the Supreme Court of the United States of America, historic issue about presidential immunity being litigated now, and Trump has already petitioned the Supreme Court for a stay. They want the lower level court to hold off on giving this trial back to Judge Chutkan so she can get the trial back on track because they want to convict Trump before the election. They're saying, hold off on this. We want to go back down and appeal this thing to the en banc bench of the entire Court of Appeals and have them all hear it and have them render a verdict before it comes back down to the Supreme Court, or maybe it's dismissed entirely. So hold off, they say. And Jack Smith does not want that to happen. But now this is from very intelligent individuals, including a former Attorney General of the United States. His name is Edwin Meese III. Also, law professors are Stephen Calabresi and Gary Lawson. And they are, again, filing in support of Trump. They're saying, Your Honor, this is all illegal. And here's what they argue in front of the 9 judges to the court. As friends of the court, amici curiae, we're friends of the court submitting this in support of Trump. They say, Supreme Court, let it be known that Jack Smith does not have authority to conduct the prosecution underlying this case. Sorry, Jack. Those actions of prosecuting a case can only be taken by persons properly appointed as federal officers to properly created federal offices. And remember how much they freak out about officers and offices in the Trump impeachment question under the 14th Amendment question for insurrection. He's an officer. Therefore, the 14th Amendment applies to him. Therefore, he can be disqualified under the 14th Amendment from being placed on the ballots. Okay, remember how much they freak out about this. Now, we're not talking about the president here, which is an own unique position. We're talking about Jack Smith. So special counsel has to be a properly appointed officer in a properly appointed office. But neither Jack Smith, they say, nor the position of the special counsel under which he purportedly acts meets those criteria. And that is a serious problem for the rule of law. Whatever one may think of former President Trump or the conduct that Smith challenges in the underlying case. They say, Your Honor, Supreme Court judges, the illegality that addressed in this brief that we're talking about here today, it started back in November of 2022. You remember the date. When Merrick Garland, Joe Biden's hitman for the DOJ, when Merrick Garland exceeded his legal authority and he purported to take Jack Smith and appoint him as special counsel for the DOJ. He didn't have the right to do that. Smith was appointed according to the appointment order. They're referencing that document that Garland released. They say Smith was appointed to conduct the ongoing investigation into whether any person or entity, including Trump, violated the law in connection with the effort to interfere with the lawful transition of power, blah, blah, blah. That was held on January 6th. Okay, so Merrick Garland came out, filled this out. He's appointed. There you go. Nobody really paid much attention to it. Now, Merrick Garland cited in that memo these different provisions of the law, 28 U.S. Code 509, 510, 515, 533. But nobody paid much attention to those, okay, other than these law professors and AG Meese. Shout out. They said, but none of those statutes, so he says, I have the authority under these statutes to appoint Jack Smith, but none of those statutes, nor any other statutory or constitutional provision, remotely authorize the appointment by the Attorney General of a private citizen, who's Jack, to receive extraordinary criminal law enforcement power under the title of special counsel. You can't just go pick out some Joe Schmo, somebody who hasn't gone through a proper vetting procedure, meaning they were appointed by the president and confirmed by the Senate. Now, they have a footnote for us here. They say no party or counsel for party authored this brief, and no entity aside from us made any monetary contribution towards the preparation or the submission of this brief. So Trump's not paying us for this, neither is anyone else. So Supreme Court, they'd say, let us explain why Jack Smith is illegitimate. Here's point number 1. First, the Appointments Clause under the Constitution, it says this, Article 2, Section 2, Clause 2. It says all federal offices not otherwise provided for in the Constitution Constitution must be established by law. That's verbatim. And there is no statute, meaning law, establishing the office of the special counsel in the DOJ. Okay, so they just made it up. He cited a bunch of other stuff. So if the Constitution, in other words, doesn't explicitly say it exists, then you got to have a law to say it exists. It makes pretty logical sense, unless you're Merrick Garland. Now, the statutory provisions relied upon, meaning these statutes, 510, 1533, and 509, that they rely on, they say that's our authority for Jack. All of them and lower courts have appointed special counsels. They do not authorize the creation and the appointment of special counsels at the level of the U.S. attorney. Okay, so in other words, they've just been creating this out of thin air. There is no statutory basis for it, but everybody's just been kind of looking the other way at it. It's like, well, it's the DOJ. They're not going to, in other giant government bureaucracies and institutions, they interpret the rules to give them more power than they have. And Congress is, useless. So what are they going to do? And if the DOJ is, running roughshod and exploiting this, they don't want to be the subject of some special counsel investigation, so they can just do it. So United States versus Nixon does not hold to the contrary. They say there's other case law that they rely on for that, but they say that's not valid. It's not a valid case because no question was ever raised in that case about the validity of that counsel's appointment. So in other words, they cite this case to say, we have authority. States versus Nixon allowed us to do it. But they say, but that was a whole separate issue. There was no actual issue about the appointment of counsel in that case. So don't say that it's related, right? They may have talked about it, but it's not controlling. It's not, necessary to the holding. And second, former AG Edwin Meese says to SCOTUS, even if one overlooks the absence of statutory authority for the position, say, okay, maybe it's not specific. There is no statute specifically authorizing the Attorney General, rather than the President, by and with the advice and consent of the Senate, to appoint a special counsel. So anyways, continuing, they say under the Appointments Clause, inferior officers can be appointed by department heads only if Congress so directs by statute. Constitution says that, and so directs specifically enough to overcome a clear statement presumption in favor of presidential appointment and senatorial confirmation. So no such statute exists for them, right? There are clear rules. They're not identifying it, and they can't identify it because it doesn't exist. Now, third, the special counsel, if he is a valid officer, is a principal officer rather than an inferior officer, and thus cannot be appointed without senatorial confirmation regardless of what any statutes say. So remember, the Constitution is the supreme law of the land. We see times when statutes conflict with the Constitution, and generally Congress will write the statute. They'll say, we have the right to do this and that, and then somebody will file a lawsuit. No, you don't. And the courts will say it's out of alignment with the Constitution. It's therefore unconstitutional. So if Congress, passes these statutes, which we referenced earlier, so let's remember where we're at in the law. Congress is using 28 U.S. Code and these different provisions. So they're saying these statutes give us power, but if those statutes conflict with the Constitution, then no, they don't. So they say this is true as a matter of original meaning, even true as a matter of case law. These other cases can plausibly be read to say that any person who is in any fashion subordinate to another executive officer other than the president is an inferior officer. And such a reading of these decisions leads to ludicrous results that there is only one non-inferior officer in every executive department. So they say, to be sure, now there are times when the appointment of a special counsel is appropriate. Okay, you can't do this. Like, you can have special counsel, and the statutes and the Constitution provide ample means for those appointments. How do we do it? Easy. We just use existing United States attorneys. For example, Patrick Fitzgerald. He was the U.S. attorney for the Northern District of Illinois. He was appointed by the then acting Attorney General to investigate the Valerie Plame leak, right, with Dick Cheney, now which occurred within the District of Columbia. So he was already a U.S. attorney. Just go get someone. Fitzgerald was a Senate-confirmed officer of the United States. He prosecuted Cheney's chief of staff, Scooter Libby. Other recent examples include John Huber and John Durham, who were already U.S. attorneys, lawfully appointed. Now, what the statutes and constitutions do not allow, however, is for Merrick Garland to go and just pick some private citizen who was never confirmed by the Senate as a substitute U.S. attorney under the title special counsel. Just go pluck someone out from the international. Hey, do you hate Trump? Perfect. Come on over back to America, as happened here, which is what they did. Now, that appointment of Jack Smith was unlawful, as are all the legal actions that have flowed from it, including Smith's prosecution of Trump. He had no root power. He had no authority to even begin, convening a grand jury. So everything that happened based on unlawful authority has to go. The whole case has to go. And AG Meese and these law professors, right, they say, look, Supreme Court, given their interest in and the demonstrated commitment to the rule of law, the legal issues this brief addresses is particularly important to amici, us. The Honorable Ed Meese III, he was the 75th AG of the United States. He was counselor to the president, and now he's Ronald Reagan's distinguished distinguished fellow emeritus at the Heritage Foundation. Now, during his tenure as AG, the DOJ steadfastly defended proper limits on federal power. We don't want the DOJ to give themselves more power. This statute kind of says that we can do whatever we want. Perfect. Let's make that happen. Professors Calabresi and Lawson, they're scholars of original public meaning of the Constitution, and Citizens United Foundation are dedicated to restoring government to the people by promoting federalism, free enterprise, individual liberty, and limited government. And we don't want the DOJ to continue to gobble up additional power that is not theirs. So here's what they tell us. In front of the Supreme Court, Ed Meese says, Your Honors, the legality of so-called Special Counsel Smith's appointment, it must be conclusively resolved before the trial. So Supreme Court, you have to stay this case and resolve this issue before you don't stay this case and send it back down to Chutkan's courtroom for trial. They say the legality of Jack Smith's appointment is potentially a fatal flaw in this entire prosecution. And as such, it must be resolved before this case proceeds to trial back with Chutkan. That reality alone warrants a stay by this court. So you can pause it while we address this. And an order directing the lower courts to address this issue expeditiously. So SCOTUS, tell them you're on hold and you want this issue briefed and you want a ruling on this from the lower courts, specifically the Court of Appeals. Address this issue. Do you even have jurisdiction to hear this case if Jack Smith is illegitimate? The answer is no, you don't. The whole thing needs to go. Now they say, although this court could itself reach this issue now, of course, it's Supreme Court. They could just say, yeah, good point. You're right. Jack Smith, you're illegitimate. Get out of here. They say, hold off though, Supreme Court. Supreme Court should wait for the lower courts to opine in the first instance, right? Let them hash it out. There's a beautiful thing about the adversarial process in American law, for all its faults. The adversarial process is both sides are very self-interested. Government wants to, go for a conviction. I think they have a little too much, well, a lot too much of an enthusiasm for it these days, but they should be wanting to do justice. And so they're motivated to convict. The defense is motivated to acquit. Through that, you get some justice sometimes, right? You get to some truth because both sides are fighting in their own interests. Madison talked about this, I think, in Federalist 51. The way to get a society with self-interested, very even selfish people is by pitting ambition against ambition. Iron sharpens iron. Both sides get stronger when you're attacking each other a bit. So you are then able to come to some level of truth. So let the lower level courts hash this out. Let's see what the DOJ says about this in Chutkan's courtroom. Let's see what Jack Smith says. I am legitimate. I'm a real boy. The court, they say, has expressly included appointments clause objections in the category of non-jurisdictional structural constitutional objections that could be considered on appeal whether or not they were ruled upon below. So in other words, just because nobody raised this case, because nobody came out here and said Jack Smith is illegitimate, like in other words, Trump didn't make this argument, you can still rule on it because it's a jurisdictional thing. In other words, it could solve the whole thing. And so we don't want to waste our time on talking about issues when there's one threshold issue that hasn't even been decided yet. In this case, however, prudence dictates that the court should wait because this is a court of review, not of first view. Nice alliteration there. This is a court of review, not of first view. It is generally unwise to consider arguments in the first instance. And they say, by the way, the implications of the appointments clause issue here, Your Honors, in the Supreme Court is nothing short of historic. And the court would benefit from allowing both the district courts currently handling the prosecutions of the former president, that's Trump, in the District of Columbia and the Southern District of Florida, where Jack Smith is presiding over both cases, to examine the issue and give the losing party the opportunity to be heard by the DC Circuit, the Court of Appeals there, and the 11th Circuit respectively. So in other words, send this back down to the first layer courts in Judge Chutkan's courtroom in DC, in Judge Cannon's courtroom in Florida. Let them hash this out, okay? Jack Smith thinks he's so legitimate. He can make his claim there, right? Make his position known. Verify that he is someone who is apparently lawfully appointed, even though he's a private citizen, never confirmed by the Senate, never appointed by the president. And he's got a lot of power to just do whatever he wants, right? As someone who brings criminal charges against the former president. So he's got a lot of power. He's his own little DOJ. So they say if we go that route and you give it back to them, it is highly likely that all those courts will examine the issue on an expedited basis. Because if they find that Jack Smith's illegitimate, then he's got to go. Now imagine what would happen if we had a split on this, okay? How fun would that be? Oh, I can just see it now. It goes back down to Chutkan. She's like, Jack Smith is a real boy. Yeah. And she gives him an apple or something. And then Cannon says, no. You're totally illegitimate. Go back to The Hague. And we have a circuit split. Now SCOTUS has to rectify and solve these things. This is especially true because the reason summarized in this brief, the law as articulated by this court, is sufficiently clear that it should not take the lower courts long to invalidate Smith's appointment. So it's going to be an easy question, by the way. Like once this lands on Chutkan's desk, even she's going to see very clearly that Jack Smith has got to go. So for that matter, they say Supreme Court, this question should be resolved resolved even prior to Judge Chutkan resolving any claim of immunity asserted by Trump. So remember, we're at the Supreme Court now talking about presidential immunity. Does Trump have it? They tied this back to Marbury versus Madison and the idea of separation of powers. The courts can't sit in judgment of the president's official acts. Otherwise, the court is the president. Okay, Liz Cheney in Congress can't sit in judgment of the president's act and say, he should have made a phone call. Okay, otherwise, she's the president. So no one cares what she says. So that's the point. But before we even get to that issue, and that's a big question about presidential immunity and all these things, shouldn't the person bringing the charges in the first place be legitimate before we even, start going down this line? So Trump, he should not need to assert any defense in the first place. Why is it his burden to bring up a presidential immunity defense when the prosecution in the first place is illegitimate? He shouldn't even have to talk about immunity. Immunity, he's being charged by Jack. And for that reason, they say, amici, we will promptly present their material, that's us, the friends of the court submitting this filing, former AG, to the relevant trial courts. Very nice of them. They say, don't even worry about it. We'll send him a copy of our prior filings. We'll get him up to speed. We'll send Chutkan everything she needs to know. We'll even highlight it. We know how much she likes highlighters. So that the district judges can rule on this issue with dispatch and in posture that is procedurally correct. Now, amici, that's us, therefore expect that this court, the Supreme Court, will be squarely presented with this issue in very short order. And you, Supreme Court, will have the benefit of percolation in the lower courts. And I happen to love that word. I love when things percolate, especially here on the channel, where I got a lot of things percolating here. A lot of cases we're watching are percolating all over the place. So for these reasons, this court, the Supreme Court, in the meantime, should not treat the current stay application as an actual petition for certiorari. So Trump's team basically said two things in the original petition and the application for a stay. There were two things. One, Your Honor, Supreme Court, you don't need to hear the issue about presidential immunity. Just accept our stay. Tell the lower level courts, don't give the case back to Chutkan to put on the trial docket and the trial calendar again, and allow us to appeal to the full Court of Appeals en banc in the DC Circuit. And if the court does that, then the trial is stayed. Then they can re-appeal to the Court of Appeals, the full panel, get their ruling on it, and then things can, work their way up to the Supreme Court again if necessary. So they're saying the Supreme Court, that's definitely the way that you should think about this, is give it back down to the lower court. Don't accept it as a petition. That was Trump's backup plan. He's saying, look, if you're not going to grant a stay on the lower level court, in the alternative, accept Supreme Court our petition for certiorari, and then issue a ruling on the ultimate immunity issue and get that scheduled for oral arguments and all the things. So we're still waiting on a response from SCOTUS, but they say treat it as a stay. Now, the court should instead, SCOTUS, follow the normal procedure under Supreme Court rules. Don't have to do anything fancy here. They're the ones out of DC who are trying to accelerate this, make everyone go very fast. But just follow the rules, they say. That should allow ample time for the lower courts, like Chutkan and the DC Circuit, to first rule on the appointments clause issue. Is Jack Smith properly appointed, yes or no? Presented by the prosecutions that are currently led by Smith. And if necessary, we can also have subsequent review of that question in this court. So let him brief it, let him duke it out at the lower level, and then we'll see it back here. Now, they say also, Your Honors, Supreme Court, we want to be crystal clear about this. Jack Smith's designation as special counsel, it violates the Constitution and the appointments clause. Why? Smith's lack of authority to prosecute Trump, it follows from first principles. Let's just go back to blank slate. Let's just see how this works. In our constitutional system, pretty obvious. Congress alone has the authority to create federal offices that are not established by the Constitution. Constitution says it exists, it exists. Otherwise, Congress gets to create it. That's the legislative body. You don't want the president to just create a bazillion new offices for himself. I need this, and I need this, and I need this, and I need this, and no. So the Attorney General also cannot ex nihilo fashion offices as he sees fit. Okay, so the executive branch, Department of Justice, they don't also just go to create, we need a department of this, and another one, and another one. And so nor has Congress ever given the Attorney General power to appoint a special counsel of this nature. So the executive branch fills the jobs that Congress creates. We have an open position here. Great, we'll fill them. They never created Jack Smith's office or one of his nature. And so thus, without legally holding any office, because it doesn't exist, Smith cannot wield the authority of the United States, including his present attempt to prosecute a former president. And that alone, SCOTUS, is a powerful reason to grant the present application for a stay. Only Congress can create a federal office, not Merrick Garland and Jack Smith and Joe Biden. The Constitution vests executive power in the president. The Constitution says so. And then it says that the power to create federal offices goes to Congress under the Necessary and Proper Clause, Article 1, Section 8, Clause 18. It says Congress has the exclusive power to create federal offices. The law professors wrote about that. Steve Gallibresi and Gary Lawson. Shout out to these two. And they're citing other cases. Now, English English monarchs, right, basically would be the executive branch, they could create offices, but the founders consciously denied that to the president. Could you imagine if Joe Biden could just create offices? Oh gosh, what would we have? Office of the ice cream, probably band stairs, you know, all sorts of stuff. He'd turn it into like whatever he wanted. We have a billion more bureaucracies and institutions. So they took that away specifically. No, so they just give it to Congress. Congress does it. Now, accordingly, the Constitution does not give the president or department heads power to create any offices or appoint whatever officers that they deem appropriate. Instead, it requires that Congress first create all the offices to which they appoint the federal officers. Okay, Congress creates the offices, and then federal officers can be appointed. Okay, and there's two types of officers, whether they're principal or inferior. Now, the Appointments Clause confirms this, and it provides for the appointment of officers, as we see, which are established by law, and law is Congress. The framers emphasized the phrase in 1787. They said that plain import of law is statute. That means Congress. That's capital L, law, consistently in the Constitution. And so if there is no statute, then there is no law, and there is no office to which someone can be appointed. We're following the bouncing ball. And there is no office. It doesn't exist. And here, no statute that exists authorizes the appointment of Jack Smith. The Department of Justice and their current statutory structure that they're relying on, it includes this: an attorney general. This is what the law says, right? The statute. You get one AG, you get one deputy AG, and you get various other offices, not including more than 100,000 DOJ employees. And the vast majority of federal workers, including those at the DOJ, are not officers of the United States. They're just employees, and their appointments are not governed by the Appointment Clause, and therefore they do not require specific statutory authorization because they're employees. Now, for their appointments, it suffices to provide, as Congress has done. Congress has said this: each executive agency may employ such number of employees, okay, because Congress wrote that in the statute, of various classes recognized as may be appropriate. But officer positions, okay, not employees, must specifically be established by law. And Congress can't undo that, even if they want to. Okay, we know they dump all over the Constitution every chance they get, but Article 2, Section 2, Clause 2 says it. So employees then cannot exercise the powers of officers. So we're being clear here. Now, we also had this in 1978, the Ethics in Government Act. It added into this mix. It said, okay, officers, offices, we have employees, and you can't just create these things out of thin air. Congress has to specifically provide for them. They did in Section 3101. That's why we have employees. But if we had a special counsel statute, we'd see another statute for this. And we're going to not see that as we go on. So they say back in 1978, the Ethics in Government Act added this other thing called independent counsel. And you've heard this get confused oftentimes in the media. They'll say he's independent counsel and say, actually, no, he's not. That's old. Like you're thinking about this. You're remembering back, 20 years ago. Appointed, they added in this, a special 3-judge court upon referral by the AG. But the statute for this independent counsel, that all expired back in 1999, okay? Congress created a new office, independent counsel, and then it expired. So that's all dead. Now, shortly before that expiration, Attorney General Janet Reno, remember her, she promulgated regulations which, if valid, are still in force today. So she just wrote this out of her, derriere. She pulled it right out of there and provided for an Office of Special Counsel. And what they did is, you see this here, 28 CFR. These are called Code of Federal Regulations, the CFR. So we have the statutes, which are the law. Congress passes that, they read it, like the 1,000-page bills that we all get, whatever. And there's a bunch of garbage in there. But even as big and disgusting as those bills are, they still don't have a lot of rules about how those apply and how the application and the interpretation of the rules are. Like you probably, similar stuff, like there's stuff that you do when you're working, and then there's kind of an explanation of the things that you do when you're working. So you're kind of doing the things, and there's rules about how to do the things, but it's not actually the thing. And so there's layers to all of this, right? How do you implement? That's what the Code of Federal Regulations are. So there was no statute. Now, under these regulations, which they modified, Joe Biden's modifying them again to waive student loans, and we're just changing the rules, right, of the statute. We're not changing the statute because Congress can only do that. So we're just adjusting the rules a little bit and how they apply. So Reno pulled this one out, said under these regulations, she said, the Attorney General may, in some circumstances, she pulled this one, says appoint an outside special counsel to assume responsibility for this matter, and wrote those in the rules. Now, the regulations clarify that outside means someone from outside the United States government. That's in the regs. Now, the Reno regulations, like the independent counsel statute, which actually was authorized by Congress, it contemplates an appointment as a putative inferior officer of a non-governmental official to an office that is fully the equivalent of a United States attorney. Okay, so it comes from these regulations, the CFR. But they say they can't do that. Janet, it, but only a statute, which is passed by Congress, not a regulation, is the kind of law that the Constitution says is valid, that can establish a federal office under the Appointments Clause. And currently, there is no statute that creates a special counsel with the jurisdiction and the authority that Smith wields. So if Congress wanted a special counsel or an independent counsel, they could have done it. They could have reauthorized this independent counsel thing, and they didn't do it. So Reno just kind of shifted it, right? Well, we're losing that. We really want this. So she just recreated it and changed the regulations, changed the rules. And they've been living on that ever since. Nobody's challenged it. So Reno and her regulations, the Reno regs, they cite these other authorities, 301, 509, 510, and these through 519, and so on. And in his order, when Merrick Garland came out and said that Jack Smith does have this authority, he relied on those too. He put out his document and he said, we have a power to do this by 509, 510, 515, and 533. But unfortunately for Merrick, these statutes, says former AG, and he's telling this to SCOTUS, they're busted. These statutes singly or collectively, they provide no such authority to allow Jack Smith to exist. Now, in his response, Jack Smith is whining again. He drops a footnote claiming that the plain vanilla language of 28 U.S. Code 518A authorizes him to prosecute Trump. Now, he says, that's Jack Smith hiding quite an elephant in that mouse hole. For the reasons that follow, Smith must be an officer to lead this prosecution. He cannot be an employee. But the fact remains that Congress created no such office, and 518 does not confer office-making power. Sorry, Jack. They continue telling SCOTUS. All right, Your Honor. They say, first, let's go through the different law that Jack Smith cites and explain why he's dead wrong on them all. First, Section 301. This is pretty obvious. This is a general authorization for issuance of regulations by the AG. They said that the AG, the head, may prescribe regulations for the government. It's a housekeeping provision. This provision doesn't create any offices or authorize the creation of any offices. Indeed, if it did, if it were a general office creation, authorization to create offices, the entirety of the more numerous specific provisions would then be superfluous. Okay, if you just got it from 301, then you wouldn't need any of the other statutes. It obviously doesn't do that. It's regulations. Now, second, Section 509. It says that all functions of other officers of the DOJ are vested in the AG. Now, rather than authorize the creation of offices, it says the AG can control his subordinates. So why did Merrick Garland put that in there? Or that Merrick Garland can exercise their responsibilities. So it doesn't say that Jack Smith has the power to exist at all. Section 510 says the AG may from time to time make such provisions as he considers appropriate, authorizing the performance of any other officer, employee, or agency of any function. But here they say again, it provides for shifting authority among DOJ personnel, but it says nothing about who those people are or how they got there. Okay, they're saying, okay, yeah, sure. Like if you're an actual officer, you can move this around for you. Or if you're an actual employee, then that's great. Or if you're an actual agency, you can move performance, right, by any other, shift stuff around. Change this, you're in charge here, you're hired, you're fired, whatever. But you don't, that doesn't create the office of the special counsel because of that power. And fourth, Garland also cites 515, and the Reno regulations relied on all of those from 515 to 519. They say, look, again, singly or alone, none of these provisions come even close to authorizing the creation of a special counsel or allows Merrick Garland to appoint a private citizen to that. 515A confers only the following power. It says the AG or any other officer in the DOJ or any attorney specifically appointed by the AG under law may, when specifically directed by the AG, conduct any kind of legal proceeding, whether or not he's a resident of the district in which the proceeding is brought. Sounds pretty broad. But thus, they say, this does not authorize creating any offices. Instead, it concerns the powers of those who are already appointed to offices under the law. So if it is created, then you can be appointed to it. But it doesn't allow you to create a new one. It allows the U.S. Attorney General to designate a U.S. attorney or a special attorney who is appointed under the law to prosecute a case, whether or not he's a resident. And so it's just a jurisdictional provision, and it doesn't give power to allow private citizens who are not appointed to be as special counsels. Section 515 doesn't give authority either. Each attorney specifically retained under the authority shall be commissioned as a special assistant. They say here, this does not grant any power to retain or hire new officers. It provides that attorneys that are already hired or retained and who may be only employees, not officers, can also have a title or salary. And to be sure about this, both provisions of the law assume that they are going to be attorneys specifically appointed by the AG under the law, which means something, right? It's got to be appointed under the law and specifically retained under the authority of the DOJ. And indeed, other provisions also also authorize them to hire people as special assistants. But these provisions confer no authority to create offices. And similarly, these other provisions concern the internal allocation of authority among existing DOJ personnel. Again, no power to create offices. No office creating power here either. And fifth, finally, they say this points to Section 519, noting that there are special attorneys appointed under other provisions of the title. But Section 543 is explicit authority to appoint special counsels. Yet they're saying like there are abilities to appoint special counsels. They say, yeah, you can appoint a special counsel, but neither the Reno regulations nor the Garland memo that appoints Smith makes any mention of this provision, because that provision does not authorize the kind of special counsel that was contemplated here. Instead, 543 is narrowly cabined, very narrowly cut off, as one would expect. The government has steadfastly for decades refused to rely on this provision that explicitly provides the Attorney General with hiring authority, and it continues to refuse to rely on it here for the obvious reason that the provision contains internal limitations which the government seeks to avoid. So if they use a provision that gives them power, then they actually lose power. The text says, the Attorney General may appoint attorneys to assist U.S. attorneys when the public interest so requires, including the appointment of qualified tribal prosecutors and other qualified attorneys to assist prosecuting federal offenses in Indian country, right? They like, darn it. So the one provision that gives them power to actually do this thing, they're grasping at straws to find, well, that kind of talks about hiring, so we'll use that. That says some regulations, so we have that. They call this sort of a penumbra of rights, the Supreme Court has said. You have a bunch of these provisions that like kind of talk about it, but not really. You can kind of presume that there's a penumbra of rights. And they got a lot of our right to privacy in that context. Whether, you think that's good jurisprudence or not, that's another conversation. But that's where they read it. You have all these other rights in the Constitution, so there's kind of this implied right to privacy, which is why we have, rights to privacy with contraception and stuff like that. But they're trying to do the same thing here. Well, because these statutes kind of say we can hire people we want, create regulations to hire that, move work around, we can just create a special counsel. Well, there is another provision that says, here, you can absolutely create a special counsel for Indian affairs. Now, this is an obvious and explicit authorization. Like, that's exactly what they're looking for, but they just don't want that Indian affairs thing. Congress put that in there. Pesky Congress. So they could use that, and these people would merely, though, assist, okay, see that word there? Assist U.S. attorneys, too. Just assist when public interest requires. That's not what they want. They want Jack Smith to run the whole thing. So there are, moreover, contexts in which the appointment of these people makes sense. Government often encounters problems where private lawyers have expertise, and you may not want a permanent government position. It's special. It's limited. An appointment as a special prosecutor under the control of a U.S. attorney is a win-win. But the problem for the government in the case of the Reno regulations and Jack Smith's appointments is that those regulations and the Smith appointment, they do not contemplate special counsels who assist U.S. attorneys. They contemplate a special counsel who replaces a U.S. attorney in specific cases. We know this about Jack. He was not appointed to assist a U.S. attorney. No, Jack was hired as a powerful standalone officer. Jack replaces, rather than assists, a U.S. attorney. This is precisely the role that the EGA previously authorized for independent counsels. Okay, we already had a law that says you could do that, but that statute no longer exists. Congress let it expire. And if we don't have a statute or a similar one, then there is no statutory authority of special counsel Smith to exist. He's not allowed to function as a stand-in for a U.S. attorney. Now, the rest of the law confirms this. This is a part of the law that deals with the FBI. It says the Attorney General may appoint officials to detect and prosecute crimes, to assist in the protection of the president, to assist in the protection of the AG, to conduct other investigations about official matters under the control of the AG, as may be directed by the AG. They say, okay, but that's not a general authorization to the AG to appoint officers. It specifically and solely authorizes the appointment of other officials, okay? Not officers, other officials connected with the FBI. This does not include special counsel. We know this. Why? Different sections of this tell us. First of all, this deals with the FBI, okay? It's about investigating things, not prosecuting things. This concerns the FBI, not the AG. Section 533 also deals with FBI officials and agents, not special counsels. This is how the government has understood this provision. It's an FBI law, not a DOJ law. And the other law is about officials. It's not officers of the United States. They are non-officer employees. FBI agents, they're subject to supervision of officers of the United States. The FBI needs office and field personnel to do its job, and so that law allows the agency to have them. That's what it's for. But those personnel are not officers of the United States, and they don't get to prosecute people like special counsel. Now, to the contrary, the word officer is literally a constitutional term of art. They tried to shove Trump into that as the president, and we'll see what SCOTUS says about that for the ballot removal issue. Now, not only because it is used that way in the appointments clause, Clause, but also because Article 2, Section 4 allows for the impeachment and the removal, there you go, of all civil officers of the United States. Congress can try to impeach the Deputy Attorney General or the FBI Director, but no one thinks that Congress can go impeach DOJ trial attorneys or field personnel at the FBI. They impeach the officers. Now, what is more, officers can be put by Congress in the line of succession to the presidency, but no one thinks that the officials at the FBI or DOJ trial attorneys are going to be in the line of succession to the presidency. That is not how Congress was using the term. And third, and perhaps more tellingly, they say a cavalier reading of the law that Jack would be relying on to authorize his special counsel hiring, it is beyond its obvious scope. It obliterates the structure of the rest of the law. Now, that title is directed into different chapters. We got a chapter for the Attorney General, a chapter for the FBI, U.S. Attorneys, Marshal Service, U.S. Trustees, ATF, and so on. Wide-ranging special counsels like Smith are not part of the provisions outside of the law that has already expired. But at a more granular level, they tell the Supreme Court that if you have a loose reading of these statutes, the effect of this would even be more bizarre. Congress has provided for the Senate-confirmed presidential appointment of these people: Deputy AG, Associate AG, Solicitor General, 11 Assistant Attorneys General, plus assistants for each, and 1 U.S. Attorney for each judicial district, and there are 94. All of those people have to be appointed. Now, a reading of 533 to empower creating unlimited officers wreaks havoc on this structure. Like, we have articulated hiring allowances pursuant to Congress. So if the AG can just do whatever he wants, then what do we have all of that for? It would allow the Attorney General to appoint an entire shadow DOJ to replace the functions of every statutorily specified officer. No wonder the Reno regulations didn't use that provision in their argument. Now, moreover, for the reasons described in depth in other pages, the Supreme Court case from 1974 did not pass on the scope of that law. That decision is dictum, okay? It provides no weight. Anyone tempted to rely on Nixon should read the case brief, because that was not an issue there. Those issues involved only the relationship between the president and the DOJ as an institution. The same arguments would have been raised if Attorney General personally, rather than independent counsel, had brought the suit. So it's not about special counsel, the case. And Nixon was argued and decided before the modern rebirth of the Appointments Clause, and those dates are too close. So don't rely on that bad case law. Now, in short, the position that supposedly held by Smith was, quote, not established by law. It's not established by law. The authority exercised by him as a so-called special counsel, it far exceeds the power exercisable by a mere employee. Jack is acting as an officer, but aside from the specific offices listed above, there is no office for him to hold. That alone robs him of the authority to represent the United States in any capacity, including before this court. They say, Your Honors, as they conclude their argument to the Supreme Court, he says the Appointments Clause establishes a default rule that all principal officers, if you're going to be a powerful officer, you got to be nominated by the president and confirmed by the Senate. Saying even though existing statutes authorize appointments of standalone special counsels with the powers of a U.S. attorney, Smith was not properly appointed to such an office. You can do it, but you didn't do it here. No statute clearly authorized his appointment by any mode other than nomination by the president and confirmation by the Senate. There's no law. They just cobbled it together from a bunch of other provisions that, as we just read through, do not apply. Any such statute, of course, is governed by the Appointments Clause. The law has to be subordinate to the Appointments Clause unless it's a constitutional amendment, and it redoes that. And the Appointments Clause makes three things clear. One, the default mode of appointment of all officers is a presidential nomination and a Senate confirmation. Two, this default presumption can be overridden by Congress for inferior officers. Third, even then, Congress must clearly speak to authorize a permissible mode of appointment for those officers other than presidential nomination and Senate confirmation. So if Jack Smith was legitimate, he either would have been appointed by the Senate or he would have been relying on a law that allowed him to be appointed as an inferior officer, if you believe he's an inferior officer. And then that method of being appointed must be clear and come from Congress. You can't just cobble it together from regulations that Janet Rigo passed. They say this is called the clear statement rule. It's implicit in the Appointment Clause and in our constitutional structure. That clause is both a separation of powers and a federalism provision. It divides appointment power between the president and the Senate, not between the president and the Congress as a whole. The Senate is the body in which every state gets equal representation, and that guards against large state presidents underrepresenting smaller states in the executive and the judicial branches. These structural concerns warrant an interpretive presumption in favor of a clear statement of congressional intent to authorize appointment by any other means than a presidential nomination and a Senate confirmation. This is a major question question, you got to be clear about it in the law. And even without such a presumption, ordinary statutory interpretation, it demonstrates that the Attorney General had no power to appoint special counsel as inferior officers. None of the statutes canvassed in the previous section contain that authorization. In contrast, the DOJ's organic statute, the organic statutes in other cases, they do contain inferior officer appointment power clauses. So like when the DOJ is talking about investigating agriculture cases or education cases or health and human services, there are inferior officers that are articulated there. But Congress gave the Attorney General power to appoint such additional officers as he deems necessary, but only for the Bureau of Prisons, okay? Not for other DOJ components. The Congress set the limit. Congress's reasons here are unclear, but no one cares. It's irrelevant when statutes are unambiguous. Doesn't matter. They said you get it for this power, but not for the other stuff. Don't like it, take it up with Congress. Now, even if special counsels were statutorily authorized, they would need a presidential nomination and a Senate confirmation, and that did not happen here. If Jack Smith actually had the power to convene grand juries and to issue subpoenas and to direct and conduct prosecutions and to litigate in this court, he would obviously be an officer of the United States, okay? Because that's what attorneys do. That's what a U.S. attorney would do, and their subordinates would do that. He would not be a mere employee. Now, more than that, he would be a principal officer, and by the plain terms of the Appointments Clause, principal officers must be Senate confirmed. That is not how Smith was appointed, and thus he could not serve as special counsel, even if a statutory position validly existed, because the mode of the appointment was not conducted appropriately. Special counsels that Janet Reno tried to cram through are equivalent to, if not even more powerful than U.S. attorneys. Now, it's obvious that U.S. attorneys are superior officers, and the same is true of the special counsels who mirror them. The only plausible argument to the contrary rests not on the meaning, but on a wild overreading of this court's prior decisions, and those decisions contain language that some lower courts have read to mean that anyone who had a superior on an agency must be an inferior officer. But if that were true, then the Solicitor General, even the Deputy AG, would be inferior officers because they answer to the AG. Could Congress therefore let the Attorney General appoint the Solicitor General? No, of course not. So, right, there's logical inconsistencies if you read it the other way. Wrapping up, they say, one can be a superior rather than an inferior officer in two ways. One is to have no decisional superior other than the president. Smith's court filings insist that he is independent from Merrick Garland. Now, he says, right, I don't report to anybody. And even the president assuring the courts that there is no coordination with the Biden administration. So he might be the most powerful man in America because he has all this power and he reports to no one, which includes Attorney General Garland and President Biden. They say coordination with Biden is non-existent. So he doesn't report to them at all. And he didn't get confirmed by Congress or by the Senate, and he wasn't appointed lawfully. He's just this random dude who just got a job. Smith, thus, he has no functional superior. Even they admit that, necessarily rendering him a principal officer, kind of like the president, I guess. And this lack of accountability only compounds the invalidity of his purported appointment. As Justice Souter wrote in another concurrence, having a superior officer is necessary for an inferior officer status, but it's not sufficient to establish it. Now, either way, if he is an officer, Smith is a principal officer. He has no superior supervisor or someone directing him, and Garland does not supervise or direct him, as he said he would not when Smith was even appointed. And so Smith is appearing in this court on behalf of the United States. He is prosecuting a former president, the first time that that's happened in our nation's history. Smith is purporting to exercise at least as much power as a U.S. attorney, and arguably even more. That is the hallmark of a superior or a principal officer. Now, the absence of such an appointment means that Smith lacks authority to prosecute Trump on behalf of the United States in Supreme Court. That alone is enough to grant a stay. They say Jack Smith is the classic emperor with no clothes. He has no more authority to represent the United States in this court or in the underlying prosecution than Patrick Mahomes, Kim Kardashian, or Mick Jagger, and therefore the court should grant the stay. Yeah, and at least those other people have some talent, and they've done something meaningful with their lives other than Jack Smith, whose sole claim to fame is getting overturned by the Supreme Court and prosecuting Trump. Great motion signed by Gene C. Scher, counsel of record out of Washington, D.C., Michael Boos, and David J. Giorgiani on behalf of former AG Edwin Meese and the law professors Calabresi and others, submitting this to the United States Supreme Court, asking them for a stay, saying Jack Smith is absolutely illegitimate. And Trump might be bringing this argument up in new filings very soon. So we'll see what SCOTUS does there and whether they grant the stay and how that unfolds. We had another response here from Brian Kemp, one of the more dumb responses on this immunity issue. And here is what he said when he was hanging out with Caitlin Collins over on Trump's immunity and whether it applies rise to him in the Supreme Court.
It's in the hands of the Supreme Court where it goes that he has broad immunity from being president and that he can't be prosecuted for anything he did while he was in office. I wonder what you make of that claim.
Well, listen, I don't think anybody's above the law, you know, a Democrat, a Republican, an independent, myself, or anybody else. So that's my personal opinion.
Do you think that those cases should go to trial before?
Dumbest answer ever, right? Sounds like Liz Cheney. No one's above the law. Did you read the brief? Do you know what's happening? Nobody's claiming that he's above the law, Brian. They're saying that the president has immunity, and if you're going to prosecute him, there are certain procedural hurdles you have to jump through that are in the Constitution for very good reason. So we don't have hack prosecutors like Fannie, who's in your jurisdiction, Brian, prosecuting people who are doing so because they're partisan hacks and trying to grift off their tax dollars off their constituents. The claim is that Trump was an insurrectionist. They impeached him and they tried to convict him in the Senate. They lost. That's it. Okay, that's the end of the story on that one. You don't then get to prosecute him for other things that are within the confines, within the outer bounds of his lawful duties. Otherwise, you have a separation of powers problem, and you have someone else who's in another branch saying that the president cannot do the president's constitutional obligations and duties. So no one is above the law. It's ridiculous, right? He sounds like Liz Cheney. Someone should give him a better line.
For the election, so voters can make a decision based off that?
Well, listen, I think most voters probably feel the same way I do. I mean, we're a country that was built on laws and the Constitution, and it's you know, up to us really as elected leaders to be the ones that exemplify that in a lot of ways.
All right, so you see a lot of people talking unintelligently about all of this. Now, we're going to see what the Supreme Court does on this. I still think that the Supreme Court is going to find that there is presidential immunity because there clearly is, and to hold otherwise would be insane. So Ed Meese says Jack Smith needs to go. We don't even need to get to the immunity issue because Jack Smith is illegitimate. And of course, my friends, we're going to be here continuing to cover all the developments in SCOTUS, in the January 6th case, in the classified documents case, the Alvin Bragg prosecution, and all the rest of them. And so when there are updates here, we'll be here covering them. I hope you join us as we do. Thank you so much for subscribing, for liking this video, for sharing it with a friend or family member. Tell them we're covering all the Trump trials, and so they can also come here and understand what's going on out there. We also have some great links in the description below. We got amazing events coming up in the rest of February at watcherlodge.com. We've got Build Your Food Supply coming up, Zen Wellness for Politics coming up. We'd love to see you over there and back here on the next one.